Hi, my name is Brian Lepak. I am the chair of the Law Practice Management and Technology section of the Beverly Hills Bar Association. Welcome to our program on artificial intelligence, real opportunities for lawyers. Before I turn the program over to our panelists, I have some announcements on behalf of the Beverly Hills Bar Association. I want to first talk about BHBA membership. If you are not a member, or if you're a current member, you should look into the new pricing model that they have for membership. If you are a young attorney, especially with less than 3 years of practice, membership is free, and for law students. So please do look into membership at the website. I also then want to talk about virtual office. If you are thinking about practicing by virtual office, look into using BHBA. The address for more information on that is at the bottom of the screen, bhba.org/virtual office. I also then want to talk about the network. That is a group of professionals that is a networking group that meets once a month that gives you opportunities to develop your practice. If you want more information about that, also visit the website at www.bhba.org/thenetwork. I also then want to remind you that if you are interested in publishing materials that get the attention of other people to draw business to you, BHBA is publishing articles, so send your content to the section member for which your article would apply. And then finally, I would like to say that if you are interested in law practice management or technology issues, to consider joining our section. If you want more information about that, just send me an email, or you could do it individually directly to me or through the Beverly Hills Bar Association website. And with that, I hope you enjoyed the practice, and I'm going to turn it over to Alex and Carl. Thank you for joining us.
Good afternoon and welcome to today's presentation about artificial intelligence in the law practice. My name is Alexandra Zimonich, and I'm in-house counsel for Happiest Baby, the manufacturer of the first responsive baby bassinet. My co-presenter is Professor Carl Mannheim at Loyola Law School in Los Angeles. Professor Mannheim teaches constitutional law, intellectual property, privacy and technology, and of course, artificial intelligence. The presentation will discuss the impact of artificial intelligence on the legal profession and explain why lawyers need to use AI in order to survive and thrive in today's marketplace. We will also talk about applicability of AI in legal practice, outline the factors to be considered when introducing AI into day-to-day operations, and how to choose a trustworthy AI tool. The presentation will also touch upon ethical issues posed by AI-powered legal tools. And Carl, back to you.
Okay, with that, I'll take over. And let's see. So I'm going to share my screen here and start the slideshow that we will be using today for artificial intelligence. Since you're all on Zoom, you all have some familiarity with artificial intelligence because Zoom necessarily uses that. Both in the compression of the video and audio streams and also managing all the various connections. But anyway, our focus today is on real opportunities for lawyers. As Alexandra mentioned, we'll be covering a number of items. First, just a quick overview so that we're all on the same page as to what we mean by AI, and then some tools and ethical considerations. We'll try to do a demonstration about halfway through using artificial intelligence legal search, which ought to be interesting, and we'll see what happens with that. And if we get to it, we'll, if time permits, we'll get down to artificial intelligence and privacy, something that I'm quite interested in, but we have a jam-packed agenda today. So, starting with what is artificial intelligence. There are a lot of definitions, and one that was contained in a bill a congressional bill back in 2017. This act, the Future of AI Act, did not pass, but nonetheless, the definition of AI contained in it seemed quite appropriate to me. And that is an artificial system, namely one based on computers, that performs tasks under varying unpredictable circumstances without significant human oversight, or that can learn from their experience and improve their performance. And so that's particularly important when we start talking about machine learning. Systems that think or act like humans, have cognition, act rationally, or achieve goals via perception, planning, reasoning, learning, communicating, and decision-making. So to some extent, this is a hortatory definition. It envisions both the limited artificial intelligence or weak AI that we currently have and the strong AI that'll be emerging in the next few years. So this little mind map graphic shows the relationship of the different kinds of AI tools that are currently in existence. The one that's of most interest to us is machine learning and also natural language processing. If you have used Westlaw or Lexis recently, rather than the old Boolean searches that we learned in law school and early years of our practice, we now know that we can type a query using just common English. It gets parsed and passed through to very large corpora or databases, and that eases our ability to do legal search. The one in the middle, expert systems, isn't a true AI means, because typically with expert systems, all questions and answers are anticipated in advance. They're built into the system. And then all the computer is doing is selecting among pre-programmed answers. But machine learning is where things are heading these days. That's where the computer learns as it goes along. Sometimes it gets trained by humans, and other times it is not trained by humans. That's known as unsupervised machine learning. So that's as far as I'm going to go with the technical aspects of AI, and happy to answer any questions on that. But at this point, with this slide, I'll pass it back to Alexandra, and she'll talk about your future.
So as we can see today, existential threats to law firms are posed by software solutions which compete with traditional law firm model to offer legal services at a dramatically reduced cost. And this is evidenced by the development of legal tech and legal ops concepts and the so-called law companies. So legal tech is where you have application of technology to make the processes cheaper and faster. Legal ops is the concept of running in-house legal departments like a business, focusing on competencies like financial management, analytics, and service design to make legal function efficient, effective, and fit for the modern business. And then we have the phenomena of law companies. We have Axioms, Elevates, Integrion's, United Lexis of the world, which offered so-called legal managed services, which deliver lower cost legal work. These companies are owned by non-lawyer investors, and they get around ethics rules, which usually would bar non-lawyer investment by offering attorney-to-attorney services and avoiding direct engagement with clients. These companies offer state-of-the-art technology and processes, and they work under a direction of lawyers and compete in the same markets as your traditional law firms. We have additional examples of Deloitte entering this market. PricewaterhouseCoopers also is a player. Ernst & Young, these behemoths are all playing in the same arena. And then we have a phenomenon of law practice management, which is being highly transformed by the tech giants such as Oracle, who recently launched a global legal practice management system with the intention of expanding to the US and other legal markets. And it's utilizing and leveraging its cloud-based services to facilitate law practice management. And then let's look at the next slide, which really addresses the development of AI tools for litigators. The rise of AI as a litigation tool is directly traceable to the explosion of electronically stored information and to the financial impact of ESI to the cost of litigation. The e-discovery was really the first arena in which the technology became prominent. Back in 2012, the use of computer assistance in the analysis of ESI was first endorsed in the Da Silva case. And a couple of years later, in 2015, the same judge in the Tinto case entered the famous order, which really ushered tech-assisted review on the e-discovery scene. And today, numerous state and federal courts have validated use of machine learning and AI in response to document requests and discovery requests. It's undisputed today that a party in litigation is entitled to utilize tech-assisted review for a document production and review. E-discovery uses various AI techniques to identify specific document categories and locate relevant information. As Professor Mannheim mentioned, we have machine learning, we have natural language processing, data or text mining, concept search, topic modeling, and other techniques that AI uses. Many companies on the market today offer e-discovery services. We have Relativity platform, we have Catalyst, which reviews more than 700,000 documents in 5 days in a recent case, and also boasts the automated redaction feature, which removes sensitive and confidential information on documents. Then we have Extero's product, which combines project management software with e-discovery, so users can perform their legal research and then collaborate with others on the same platform. And this particular software was able to perform e-discovery at a staggering 95% cost saving, cutting down the number of lawyers from 100 to 5, which sounds and should sound alarming in a way. Microsoft and Target are among the customers of Extero. Another provider is Disco, which uses similar technology. Then we have Everlaw and many others, which employ prediction technology to suggest which documents are the most relevant. And the next arena in which AI tools are useful is litigation analytics, which enables the collection and analysis of historical data, which allows attorneys to forecast likely outcomes and evaluate how their cases will perform under certain conditions. For example, we have Litigation Analytics, which is a tool of Westlaw Edge, and it gives attorneys a big picture sense of how a judge might rule on a particular claim, how long such a ruling might take, and et cetera. And based on these factors, a lawyer can create a litigation strategy using the likelihood of a court or judge granting a motion or denying a motion. And prior to AI, assessing the likelihood of a certain ruling was next to impossible because of the sheer amount of data that would have to be analyzed. Another tool is Lex Machina, which is a litigation analytics tool of LexisNexis. It uses data from federal court and transforms them into live charts, and then presents this information, which includes the judge's biographical information, open cases, comparison to other judges, and case timeline, all of which suggests how long the dispute might take and what the likely outcome would be. It has a couple of other features. One is called motion chains, which provides odds of success on a specific motion. Another one is the timing analytics, which talks about an estimated time in which a case will go to trial before a specific judge. It has another feature called the party group, which allows users to select lawyers and analyze their experience before a judge or a court. That is becoming increasingly a commonplace in the litigator's toolbox. Another example is a platform called CaseText, which also allows lawyers to forecast an opposing counsel's argument by finding opinions that were previously used by these same lawyers. This really is a game changer in the litigation environment. The next example is case management and RoboLawyers, which really are chatbots, which can mimic the conversation back and forth and sound like a human. And when an algorithm-powered bot is conversing with a human being, it's drawing on millions of similar exchanges from which they draw patterns. So we have an example of a tool called Hello Divorce, which employs AI-powered chatbot to lead clients through their legal options in a divorce. And then we have another tool that is called Do Not Pay, which was launched in 2018, and it was dubbed as the world's first robot lawyer, according to its App Store description. Sue anyone at the press of a button, they proclaim. This app started as a method to appeal parking tickets, and today it assists with government paperwork, tackles customer service disputes, even finds hidden money by canceling subscriptions and appealing bank fees. The founder plans to expand it to allow users to apply for green cards and file for divorces as well. And then we have legal research, which was revolutionized by AI-powered natural language searches that return faster and better search results. Examples are Westlaw's Edge and Ross Intelligence, which can Ross can read more than 1 million pages of case law in a second, which is rather mind-blowing for us traditional approach lawyers who are used to pore over voluminous case records. And now let's look at AI tools for transactional lawyers.
Let me, Alexandra, let me just mention that Zoom is cutting off the bottom of the slides, but the full slides are available to all our attendees. There's a link in the chat panel. So if you don't have the slides in front of you now, you can download them at a later time. Here we go for transactional lawyers.
And another set of tools is useful for transactional lawyers. And these tools offer due diligence, contract review and analytics services, and risk management services. So for example, we have Kira Systems, which performs a due diligence contract review by searching, highlighting, and extracting relevant content for analysis. And then all team members can review the content by searching for the extracted information with links to the original source. The company claims that its system can complete the task of up to 40% faster when using it for the first time, and up to 90% faster for those with more experience. Another tool is a German-based tool called Leverton, which extracts relevant data and manage documents. And it reads contracts in 20 languages at high speed. Colliers International used Leverton in performing due diligence on a company that they were about to acquire, and Leverton extracted information such as payable rent, maintenance cost, and expiration dates from thousands of documents and then organized it on a spreadsheet. JP Morgan Chase is using software called COIN, Contract Intelligence, to review commercial loan agreements. The software reviews documents in seconds, doing work that once required 360,000 hours of work each year by lawyers and loan officers. It interprets about 12,000 contracts for the bank per year, and it's also said to greatly reduce loan servicing mistakes, often attributable to human error. Another tool is Thomson Reuters Contract Express, which simplifies the contract drafting process. It's a self-help tool which would enable non-lawyers in the client's company to draft contracts for themselves, empowers the business owners to make certain decisions themselves without having to go through a legal department. And the software also has a compliance add-on, so contract at the same time go through a basic compliance check. Another example is a risk management arena where a product called Thought River automates summaries of high volume contract reviews while users get content extracts and the meanings of clauses provided in the margins. The system also flags risky contracts and content automatically. Another example is the tool called LawGeeks, which uses AI to review contracts and spot missing or problematic clauses and validate certain contracts that fit within predefined policies. LawGeeks had a competition where 20 top corporate lawyers reviewed 5 NDAs, and the lawyers showed 80% accuracy, and it took them 92 minutes per individual document. The machine showed 94% accuracy, and it took it 26 seconds per document. So, which is really a staggering difference. So let's talk about AI search now.
Okay, well, thank you. Well, Alexandra went over Lexis and Westlaw. We're all familiar with them as search tools. But as an academic, I like to think of the purpose and functionality of search for lawyers. And really what we're trying to do is predict. We're trying to find relevant materials to predict outcomes and also to help us shape outcomes. Again, based upon predictions that we can assemble from the materials that we find through search. We're going to need to do some form of legal reasoning both before and after we conduct our searches. I know that for me, sometimes those parts, the pre and post search elements, are the most difficult. And as these AI tools become more robust, the way that we plan our searches and the way we extract information from our search results is going to change. Search now is going to allow us to retrieve arguments. It's going to allow us to actually answer specific questions. Natural language processing is good for that. So in addition to Lexis Answers and Westlaw Edge that Alexandra talked about, there are some other commercial tools such as Case Text, Bloomberg Points of Law, and Ross Intelligence. Ross Intelligence is a legal services firm out of Toronto that was the first to use IBM's Watson to really employ AI in legal search. Now, there are a couple of new tools that I'd like to introduce you to, and here we're going to try to do a live experiment. Very recently, Brigham Young University assembled a rather large corpora or corpuses of English language materials. And so to show you how that works, I'm going to stop the slideshow for a moment and switch over to my browser. All right, so here are a half dozen or so different corpora that BYU has assembled. Now, I am doing a lot of research into originalist understanding of the Constitution. I'm looking for terms that are either found in early modern English or the founding era in the 18th century. And so I would use those particular databases for my search. But there's also a way to search Supreme Court opinions. Now, these I have to sign in. You have to create accounts. Usually they're free if you have a limited number of searches to do. Now these are searches that will probably return the same results you would get on Lexis and Westlaw, but they will look differently to you, and therefore they might be faster or give you different insights. And so I'm just going to try this term sovereign immunity. That's if I spell it correctly. So you noticed how fast this was, by the way, and it gives me the term in context, so I can see rather immediately, rather than laboring through all the different hits that I would get on Lexis, for instance, how the term is being used, and I can then quite rapidly visually inspect and then choose the sources that I'm interested in. It will produce the documents over here, and and it will give you a little broader context and also a link to the full document. Now, as I said, this is these are tools that may, to some extent, replicate the ones you already have, but give you faster access. It also gives you statistics so that we can see that the term sovereign immunity has been used by the Supreme Court close to 2,000 times, and this may take a while, but it can also be used to find words that are nearby your search term. If that becomes important to you, such as waiver, then you can pull up the statistical information about that and then help you narrow your search. Let me introduce you to a different set of corpora. This is also put out by BYU, and this is the home page of english-corpora.org. And you can see they have a lot of different databases, including a corpus of Supreme Court opinions. We'll demonstrate that in a minute. But also goes way beyond what you would find in Lexis and Westlaw. For instance, at the bottom, there are searches through the Google Books project, and you may recall that Google is trying to digitize every book in print. And right now they have assembled about 155 billion data entries. So it's a much larger database than one would find in the commercial search engines. Again, these are just alternatives, and I encourage you to play around with them. You can establish a free account for a limited number of searches on a daily basis. So I'm going to do sovereign immunity in this database. Let me find things. So I'm maxed out on this, unfortunately, on that particular database. So let's see if I can try a different database, or you're going to have to play around on your own. Let's say I was interested in movies, and I want to look for murder mystery. I may be maxed out on all of these, I'm not sure. Give me 1 second while I sign back in. That is one really disturbing thing about this, and that is that I have to all right, well, it's not working for me as, well, it's because I'm not doing it right. Let's see if that works. It does not. All right. So back to the home page here. So that we can just see an overview of the corpuses that exist. I was also going to demonstrate the coronavirus corpus. So if you are dealing with liability issues, that's a good one to access. Unfortunately, if with a free account, which is all I have, you're limited to roughly 10 searches a day. And in preparing for today's lecture, I apparently maxed out. Any event, these are the two corpora that I highly recommend. The one at englishcorpora.org and the one at BYU, that's just lawcorpus.byu.edu, and that will give you different mechanisms. So I'm going to end this little demonstration and go back to the slideshow. And here we are. Back to you, Alexandra.
Thank you. Now, as we are talking about the variety of AI tools, we have to be mindful of ethical considerations, which we have to consider while using these tools. The first consideration is competence, which is requirement to keep up with the technology. So as lawyers rely more and more on AI and other technologies, they have an obligation to understand how those technologies work. More than 30 states have rules requiring lawyers to maintain the requisite knowledge and skill, including keeping up with changes in the law. And this obviously includes understanding the benefits and risks associated with AI. For AI, the most notable issue is the so-called black box challenge. A lawyer queries an AI-powered tool, the query goes into a black box, and the AI gives an answer. How much does a lawyer need to know about what goes on inside that black box is the question. Lawyers are not computer scientists and cannot be expected to understand the algorithmic levels working of AI systems. But at the same time, they must have some basic understanding of how the tools they use work. They need to understand the capabilities and limitations of the tools, and they must consider the risks and benefits in the context of a specific case on a very high level, obviously. Then the next consideration is going to be unsupervised practice of law. Lawyers' duty of competence includes a duty of supervision. If a lawyer delegates a task to junior lawyers or paralegals or legal assistants, there is an ethical duty to make sure the work has been done completely and competently. This duty extends to AI-based tools as well. Additionally, just as there are some tasks that should never be delegated to a paralegal or legal assistant, certain tasks are not appropriate for AI, and an attorney must know how to tell them apart. It's a question of automation versus a question of augmentation. Some tasks shouldn't be automated, period. For these tasks, AI can help lawyers to do their jobs, but they cannot do their jobs instead and completely. So the question will be, where do we draw that line? And another consideration is to think about over-delegation versus under-delegation. Just as lawyers can over-delegate work to subordinates, they can also under-delegate, which means they're serving their clients less efficiently. This same problem is evident in underutilizing AI, where a lawyer is not using AI even though it could help that lawyer serve the client better. And lawyers focus on detail, a wish for control, aversion to risk, all point towards underutilization, which really presents a greater risk than over-reliance on AI. Another consideration is confidentiality. Client confidentiality and attorney-client privilege involve confidences that clients share with their lawyers. Those confidences are also often shared with AI-powered tools, and lawyers need to ensure that client confidences remain secure at every stage of the process. This is especially true today, where every week seems to bring news of a new data breach. Lawyers should consider confidentiality of hosted data used in AI applications and the risk of data breaches. For example, when you have a voice-activated personal assistant which handles legal research questions, that is a great innovation, but it also must be secure. If all the natural language processing is done behind the law firm firewall, it's one thing, but when it's being handled by a vendor server somewhere in the wilderness, how can the lawyer know that the confidential or privileged information is adequately protected? Another consideration is unauthorized practice of law. Legal chatbots are AI-powered programs that interact with clients who have legal issues, and they simulate a conversation or a dialogue. These chatbots fight parking tickets, they advise victims of crimes, they draft privacy policies or non-disclosure agreements. They can be very helpful to consumers, especially those who cannot afford the high cost of hiring a lawyer. And they could help bridge the growing justice gap in the US and around the world. But they do raise the issue of unauthorized practice of law, especially if the chatbot is created or maintained by a lawyer. The problem here is that we don't have rules and opinions that govern these situations. So we have to balance protecting the public and also allow for innovation in the delivery of legal services. Ethics lawyers are quick to say no to legal innovators, but there must be a way to innovate and move forward to help consumers in different ways and to close the justice gap while at the same time staying out of disciplinary trouble. And so lawyers providing advice to clients using or developing AI should know what to look for in an AI tool. The number one thing is to understand the technology. No one will expect a lawyer to understand exactly how the technology works. But legal professionals must have a basic understanding of the AI technology so that they're able to consider its benefits and risks. The second very important consideration is data security. Lawyers need to be mindful of choosing a solution that ensures client confidences, which must remain secure at every stage of the process. For example, Thomson Reuters employs an information security policy that is aligned with the well-known NIST cybersecurity framework, and Westlaw offers multi-factor authentication and two-factor authentication for secure user logins. These are just some of the security features that lawyers should look for when selecting a technology tool. Another important consideration is data quality and trying to understand what kind of data is used to train the AI and whether such data contains unfair biases, because the results of the AI tools could be correspondingly biased as well. The key here is to find a provider with trusted data. And finally, making sure that the legal research work is being done competently. And we must, as I pointed out earlier, must be mindful that there are some tasks that are never going to be appropriate for handling by AI. And there are other tasks where it would be unethical not to use the technology. And the lawyers must figure out how to tell them apart. And now our related consideration is about robots in the licensed professions. And Carl, back to you.
Sure. Before I do, though, I just want to remind people that one of the handouts for today's session are some of the model rules and California rules of professional responsibility regarding the adoption and familiarity with new technologies. So just to reiterate what the State Bar in California has said in opinion number 2015-193, an attorney's obligations under the ethical duty of competence evolve as new technologies develop and become integrated with the practice of law. So just to reinforce what Alexandra was saying, this is not an area that lawyers can avoid. Now, the next area, next couple of slides, are going to talk about regulating AI and robots. Sometimes those terms are used interchangeably. Robots don't need to be physical entities. They can be software robots, which we call bots. And one of the issues here is how do licensing or professional boards supervise the competence or the use of these new technologies? Well, at the federal level, there's not much at this point. Perhaps the FTC can assert jurisdiction if there are rogue bots or AI that are creating consumer harms. But in the meantime, it's mostly going to fall within the jurisdiction of state attorneys general, their consumer protection agencies, to assure that the products, whether they're software or hardware, are safe and honest. In terms of the licensing boards, and just about every profession is governed by some licensing board, whether it's the State Bar or the medical licensing, medical examining board, or what have you. Right now, they really do not have jurisdiction over these artificial agents, but I think it's only a matter of time before they do. The California legislature has considered what to do about medical robots. As you know, medicine is one of the early adopters of AI. And right now, since these bots are not licensed, you can't pull a license in the event of malpractice, or you can't use the licensing authority to enforce discipline on a robot. Right now, the operators of those tools are going to be the ones responsible. But as AI becomes less and less human controlled and more autonomous, and that's just that's a process that will evolve over the coming years. I would expect these licensing boards to begin to take closer looks at what the robots are doing. So that raises the question of liability. What happens if you have a client that is harmed by, let's say it's a self-driving car? Well, that's already occurred. And we know that robots are going to cause harms. Artificial intelligence is going to create injuries at some point. Hopefully, less harm, fewer incidents of it than human-operated devices. But nonetheless, liability is definitely an issue that the legal profession has to pay attention to. So to the extent that we're talking about design and training flaws in the apparatus or defective manufacture or errors by human operators, then we can probably apply standard tort law to those incidents. The normal negligence standards or stricter products liability are going to map pretty well onto harms caused by AI where the AI is simply a tool of a human operator. But where, and this unfortunately the slideshow got a little corrupted here, but where the AI or the robot is acting autonomously, and let's say we have the Uber self-driving car running into the Google self-driving car, and the owners are sitting in the back seat. So it's really hard to impose or ascribe some type of culpability or liability on the owners or even the manufacturers or the programmers of the software, because as unsupervised learning becomes more dominant with machine learning, with advanced AI, which is the case with self-driving cars. Humans are not really programming these devices, they are programming themselves. And so that makes liability a difficult construct to map onto AI or robot liability. Now, this is more of an academic issue at the moment, but it will certainly become a matter for prosecutors and criminal defense lawyers, and that is, what do you do with criminal liability? Again, if the AI is simply a tool of a human, whether it's a screwdriver or a robot that kicks down the door, then the actus reus is attributed to the human, and we apply liability there, criminal liability. But again, once these AI devices start thinking for themselves, then we have to come up with different approaches to liability. So, will there be codes of conduct? Yes, there will be. They're already being developed. Will we require registration of AI devices and robots? Very likely. So that we can, just like we put a serial number on dangerous devices like firearms, we're going to be putting serial numbers on robots so that we know how to map the agent and the harm. So I wanted to, we're nearing the end, and we want to leave some time for Q&A. But I wanted to just very briefly talk about the AI from a policy perspective. At the end of the Obama administration, the National Science and Technology Council, which is a kind of a group of all the sci-tech agencies in the federal government, issued a strategic plan, which was a roadmap for both the promotion and the regulation of artificial intelligence. Not much has happened in the last 4 years, but I would expect there to be renewed interest in the years to come to developing some kind of federal legislation in this area. Right now, there is none. There's only been 1 or 2 federal congressional hearings on artificial intelligence, so we're behind the 8 ball, but that may change. For those of you who want to see what the most recent policy developments are, you can go to this UN website, the Artificial Intelligence for Good. Usually it's an in-person conference in Geneva. I attended last year. But now it's virtual because of the global pandemic. And so you can attend for free any one of their sections or their webinars all throughout the year. So I commend that to you. In terms of the policies, the overriding policy concerns with respect to artificial intelligence, I think the most potent policies can be found in the Asilomar AI principles, which were developed by the Future of Life Institute. It is now not only is it world renowned, but it also has actually been adopted by the California legislature as of about 2 years ago. Now, these are guidelines. These are not regulations per se, but as a framework, they will provide the basis for future regulation. So these are the overriding principles, many of which we've talked about today: ethics, beneficence, responsibility, and so forth. And so just staying tuned into the developments here will put you at the front of the pack. The last thing I wanted to mention on the regulatory side is the white paper issued by the European Commission earlier this year. Now, the reason the EU approach to artificial intelligence is important to us is that we know what happened with privacy regulations. When Europe adopted the General Data Protection Regulation, it applied not just to European establishments, also to third-party. That would be American establishments that either were marketing to European citizens or processing data of European citizens. So most of you ought to be aware of the GDPR and how it applies to your clients. And also bear in mind that California has recently, actually just last month, adopted a version of the GDPR, which applies to California. That's the California Consumer Privacy Protection Act. And so as with privacy in the GDPR, I think we could expect the European Commission to start developing hard rules and regulations on artificial intelligence, which by themselves will be applied to American technology companies and could also serve as a template for domestic legislation, even if at the state level. So here are a few regulatory efforts that are underway. There are some very small pieces of legislation that already are in place. California's chatbot law, the Illinois Biometrics Privacy Act, which is probably the most robust in the country. And we have other state laws. Unfortunately, lawyers have to become familiar with all of these laws if they have clients who are more than just locally based and doing any kind of work outside of the state of California. So I'm going to turn this back to you, Alexandra, to kind of close out the slideshow.
Thank you, Carl. Even though we have a lot of policy papers and we have a lot of legislative activity across the ocean, the only meaningful action in the U.S. has come from grassroots organizations, community advocates, and workers, journalists, researchers, and tech workers who are trying to pressure tech companies and governments to recognize the dangers of AI. And the issue that we have is the efforts to regulate AI are lagging, seriously lagging behind the pace at which the technology is evolving. We have some activity where certain municipalities, including San Francisco, who was, I believe, the first one to ban facial recognition technology. Some politicians are promising a nationwide ban. There is a couple of proposed bills on that pending. But despite growing public concern, the rollout of risky AI technologies continues to grow. And we can see that Amazon is partnering with over 700 police departments to utilize their Ring technology, and which is really not meant for law enforcement, but Amazon is sharing these records, which provides all kind of procedural concerns. Then we have massive government contracts to tech giants to develop AI for tracking and surveillance of refugees and residents. another problem is that AI systems amplify existing race and gender disparities, including certain dangerous theories which rely on discredited race science and physiognomy, where these companies are trying to assess personal worth and character of a person based on physical characteristics, and they're introducing these tools into classrooms and workplaces to determine who is productive or a good worker, and often doing that without people's knowledge. China is the biggest user of these technologies, and they try to employ affect recognition to identify criminals at public places. And then we have to think about the demographic differences. Who are the constituents that benefit from AI versus those that bear the brunt and the cost of its biases and exploitation? That's something to worry about. And then there are obviously concerns about AI in the privacy sphere. And back to you, Carl, to just touch on this, because this is a subject that is on its own a huge subject.
Well, the biggest threats to privacy come from automated and artificial means. As Alexandra mentioned, China is probably the poster child here for invasions of privacy with its ubiquitous facial recognition software. But of course, the US is trying to catch up to China. I published an article recently in the Yale Technology Law Journal about AI and privacy. I'd be happy to send that or a link to it to anybody who's interested. But AI, what AI does the best is process data. And the more data, the better. And that means your data. Especially as AI is being used either to monitor you or to market to you, then your data becomes its fuel. So it is really difficult to kind of take our existing privacy laws and apply them, adapt them to AI. They're really ill-suited. The last major US privacy law was enacted in 1986. And I guess one can say not much has happened in the last 34 years to merit revisiting our privacy laws. But we all know from our personal experience, we all have smart speakers and smart microphones in our houses. So your little Google Assistant, or I can't actually say what the Amazon device is, because as soon as I do, she'll talk to me and it'll disrupt this this meeting. But you know that they are tracking all of your conversations. If you are an Amazon Echo user, you can go onto your Amazon account and actually see your conversations that have been recorded by that device. So we're all giving up a little bit of privacy in order to ease into the modern world, and these are policy choices that are not very comfortable to make. We need a national conversation about them. But right now, there's a huge asymmetry of power between the tech companies who have access to our information and those of us who are trying to protect it. That's all I can say without getting into great detail on this. But the CCPA is something to keep your eyes on. Here are some additional resources, and I think this is where we're going to end the slideshow. Some additional resources that you can look at to just get some very basic ideas. I see a number of questions in the Q&A about product recommendations. Alexandra is the real lawyer amongst us, so I will defer to her on answering those.
Thank you. There was a question asking about comparing the existing products, and I'm not aware of a single source that exists that would offer such useful comparison. What I do is I sign up for various newsletters that are offered by either AI platforms or providers of these services. I typed in the answer box. One of these is emerge.com, which is an AI provider, and they have a newsletter that often gives you an overview of what is currently on the market, and I found that helpful in the past. The automated task question regarding contract review, which would be analyzing 30 services, would actually be a good fallback for, let's say, a Leverton or a Kira type tool. Obviously, it's going to be dependent on the pricing structure, and the trick with these providers is they don't outwardly offer these structures, and you have to engage with them, and sometimes they would even offer you to become a beta tester, or they would be creative in offering their product. So without actually trying to connect with them directly, I don't think the market has been developed sufficiently where you can kind of do a price comparison on this either. So that's
well, let me try to answer Michael Leventhal's question, because it's a really very important and dominating question right now, and that is, how do we protect the IP of creators of artificial intelligence or AI programs? And the answer is that that's difficult under existing US IP law. The Supreme Court has made it hard to patent software programs. There is a patent class, I believe it's 706 at the PTO, that at least acknowledges the possibility. But to patent software, the software has to do something more than simply compute an answer. It has to actually operate something outside of the computer. You can also copyright the software, but it's a thin copyright. It's hard to gain protection over the abstracted systems that the software is implementing. You can obviously protect the precise code, the object code, if that's the subject of a literal copy. But a non-literal copying of AI software may not be all that fruitful. As a result, a lot of AI companies maintain their IP through trade secrets. They will keep both the software and the databases in the cloud. Their customers can have access to that, can have get through through a paywall or a firewall, gain access to it, but they don't actually have copies of the code or of the data on their local machines or local access. Now, so I would say that trade secret is the best way to protect AI inventions at the moment. That could be challenged if the European Union adopts one of its proposals, such as requiring that all AI operating systems be open source to allow interoperability and to make sure that people know where the kill switch is, actually. That hasn't become law yet, but Europe has moved aggressively with copyright reform, most recently eliminating the safe harbor for American tech companies. So I would expect further developments in that sphere. I think the IP considerations for artificial intelligence are really important, but would be the subject of a further a session. It's quite complicated. And with that, unless, Alexandra, you have any closing remarks, I think we covered a lot of material.
We tried, and we just wanted to point out that number one, we can envision a day easily when it's going to be considered legal malpractice not to use AI, and it's not so far ahead of us. And the number two is AI has the potential to promote greater access to legal services and to enable millions of individuals and small businesses to obtain representation at a significantly reduced legal cost. So there is great potential that is going to be hopefully tapped very soon. And these are my closing remarks. And with that, we end our program. And thank you for attending.
Okay, I see there are some remaining questions in the Q&A box. I can try to answer them, but formally the MCLE session has closed. So a question that came in from Carol Scott, Carol, was whether a lawyer has an obligation to disclose the fact that she's using artificial intelligence. And I guess the answer is going to be contextual, right? If you're using AI in search, I don't think so. But if you're using AI to inform decision-making, strategies, and so forth, my guess is there's probably an ethical obligation to disclose that to your client, not necessarily to opposing counsel or to a court unless asked, but your client should be kept fully informed. That would be my my bet, or the way to do it. And then
that is in line with the chatbot law that is actually on the books in California already, where the law specifies it's unlawful for any person to use a bot to interact with another without revealing its artificial identity. So that's.
And then there's a question that came in from my copyright guru, Jay Doherty. So that would be the question that I would ask him, which is if you have a client who is an artist or a musician producing AI works, how do you protect those rights? Well, we're familiar with the monkey selfie case. I can't recall the name of the case, but where district court held that there was no copyright in that work. And similarly, the Copyright Office has recently ruled that it requires a human creator to obtain a copyright. And I believe the Patent Office is taking a similar position with respect to patented inventions. But the point is that as artificial intelligence gets more sophisticated and more creative, we're going to be seeing instances. We already are seeing instances where the machine is doing at least the line item creation, is the proximate creator of the works, whether it is a creative work or an inventive work. And under current U.S. law, there is no IP protection for them. So the answer to the question, I would suspect, and Jay really would know this better than I, is that you need to keep the human fingers involved at all points in order to be able to claim authorship or inventorship. Now in the EU, it's a little different because there is protection, sui generis protection for computer-generated works, but we don't have that in the US yet. So I think the human has to remain involved at some point, whether it's just simply selection criteria or whatever, to even have a credible claim of some type of IP protection.